Hi, my name is Michael Kemmy. I'm an attorney and I'd like to talk to you about wills and estate planning. You may be wondering if you even need a will or an estate plan. Well, let me assure you that you probably do need a will and you already have an estate plan. I know all the legal terms and technical rules can sound pretty confusing, but let's take it one step at a time. In this program, I'll be talking to you about the basics of wills and estate planning. We'll also cover areas that are more involved that may relate to your personal situation. This program is by no means designed to replace the advice of a personal attorney who can better guide you on specific situations that best suit your individual needs. Instead, this program is designed as a guide to increase your knowledge. After we've covered the basics, you'll be able to draft your own blueprint so that your will and estate plan can best meet your needs and desires and protect your loved ones. So let's get started. For many of us, the term estate may conjure up ideas of a great mansion with huge white pillars set in the middle of 5 or 10 acres with 100-year-old trees lining a half-mile driveway. Or perhaps you may simply think that someone with an estate is a millionaire. Those ideas are partly true, but in fact, you have an estate. Your estate is generally all of the property you own, your home, your furnishings, your bank account, life insurance, retirement plans, and the rest. If you own property, you have an estate. Now, your entire estate, that is, everything that you own, is made up of your probate estate and your non-probate estate. If you die with a will, you are said to have died testate. If you die without a will, you have died intestate. Probate means proving a will through the courts. This is done so that your assets can be properly administered and distributed. If you die intestate, without a will, your assets still need to be administered and distributed. The process is actually called estate administration, but most people just refer to it as probate, even if there is no will. All of your property may not have to go through probate. Those assets that do go through probate make up your probate estate. These are normally assets that are titled solely in your name and come under the control of your personal representative. If you have a will, your personal representative is usually called an executor. If you die intestate, he is usually called an administrator. Assets such as real estate, bank accounts, stocks and bonds, and automobiles are part of your probate estate if they are titled solely in your name. If you live in a community property state, your probate estate may also include 1/2 of your community property. Sometimes property titled jointly is also part of your probate estate. We'll discuss that in more detail later. And you'll better be able to understand what assets are included in your probate estate when I describe examples of non-probate assets. Now, at your death, some of your assets that you own are distributed to persons without regard to your will or the probate process. They pass directly by operation of law or by contract. These assets make up your non-probate estate. An asset that you own jointly with another that has rights of survivorship, such as a joint bank account, will pass directly to the surviving joint owner upon your death by operation of law. Another type of non-probate asset, such as life insurance or IRAs, allows you to name a death beneficiary. By contract law, these will be distributed directly to the designated beneficiary when you die. In other words, some of your assets may not be controlled by your will or the probate process. It is very important to coordinate your probate estate with your non-probate estate to make sure that your desires are fulfilled. I'll be showing you how we do that as we go along. Another closely related concept is your taxable estate. It's beyond the scope of this program to discuss in detail, but essentially your entire estate, probate and non-probate combined, is your taxable estate. When a person dies, his entire estate is subject to the federal estate tax. Most states also have an inheritance or estate tax as well, but these are usually not as significant. Whether or not your estate will have to pay estate taxes depends on the year of your death and the size of your estate. There is a tax credit that allows a certain portion of your estate to pass tax-free. The amount that can pass tax-free is sometimes called the applicable exclusion amount. The exclusion amount for many years was $600,000, but beginning in 1998, through the year 2006, the exclusion amount gradually increases from $625,000 to $1 million. The tax rates on amounts over $625,000 start at 37% and go as high as 55%. Most people will not have an estate that is subject to the federal estate tax, so we're going to concentrate on the other reasons you should have a will and an estate plan. However, if you think you may be subject to the estate tax, you should definitely consult with an attorney or an accountant. If you recall, I stated at the beginning that you already have an estate plan. Most likely, you have made many estate planning decisions. For example, deciding to have a will or not to have a will, or to postpone getting a will, is part of your estate plan. Remember, I didn't say that you have a good estate plan, just that you have one. How you have titled your property is an estate planning decision. Are your bank accounts or stocks or real estate titled in your name only, or are some of them titled jointly with someone else? Do you own life insurance, IRAs, 401ks, or other similar assets? Naming a beneficiary is another estate planning decision that you have made. So, you do have an estate plan. You may as well take control of it by understanding what you are doing. To give you a better understanding of how a will is an essential part of your estate plan, let me first explain what happens when you die without a will. If you die intestate without a will, you will have made a very serious estate planning decision. Every state has its own set of laws dictating who is to get your property when you die without a will. These are usually referred to as the laws of intestate succession or the laws of descent and distribution. In a nutshell, if you don't have a will, the state has one for you. The state determines who gets your property, who will be the administrator of your estate, and who will be the guardian of your children. These rules are very strict. There are no special exceptions for hardship or anything else, and no consideration for what you really would have wanted. The persons who take your property under the laws of intestate succession are called your heirs. The laws of intestate succession will usually divide your property between your spouse and your children. Some states may even divide your property between your spouse and your parents if you don't have children. And if you don't have children or spouse or parents, the laws has rules for dividing your property among your other relatives. Most likely, your will would be completely different from the one that the state has for you. I've prepared wills for many people who have procrastinated for years, but most often, these are the folks who tell me that they are so relieved to have finally made their wills. What's interesting, though, are some of the excuses, reasons, that people have for not having made a will. One of the most common excuses is the one that I'll call the death wish excuse. There may be different variation, but it's something like this. If I get a will, or even think of getting a will, I'll be more likely to die. The truth is, and you already know this, that someday you will die, and there is no causal relationship between making a will and dying. Isn't it better to make a plan rather than to stick your head in the sand? Something else people tell themselves is, I'll get a will when I'm older. You don't know when you're going to die. In fact, for those people who die at an age, as in most areas of life, procrastination does not pay. Another excuse for not getting a will is that some people think wills are for rich people, or I don't have enough money to need a will. Even small estates have to go through the probate process and are generally subject to the same laws. And then some just don't like attorneys, or they think that a will is going to be too expensive. But a well-drafted will can actually pay for itself. If you die without a will, most states will require the administrator of your estate to post a bond. The cost of a simple will is often less than the cost of a bond. Now that may not change your opinion of attorneys, but it may make you rethink your value of the will. A will is a statement that you make directing how you want your property to be distributed. Anyone who is at least 18 years of age and of sound mind can make a will. A will does not take effect until you die. So, as long as you are of sound mind, you can change your will as often as your wishes or circumstances change. Now, there are different types of wills, but a will almost always has to be written to be valid. A will written entirely in your own handwriting is called a holographic will. This type of will may not be valid in every state. A written will that is properly witnessed is called an attested will. An attested will with a special notarized affidavit is a self-proving will. I don't recommend that you handwrite or type your own will. I've seen too many homemade wills done by people trying to save a few dollars only to cost their estates thousands of dollars. They are frequently ambiguous or incomplete or just poorly worded. These are the kinds of wills that are often subject to lawsuits. I do recommend that you have your attorney draft a self-proving will for you. With a properly drawn and executed self-proving will, the witnesses do not have to be tracked down after your death in order to have your will probated. With any other type of will, witnesses will have to testify in order to have your will probated. And if your will can't be probated, it's no good. The cost of locating the witnesses after your death could far exceed the cost of a simple will. Also, it's a lot less expensive to pay an attorney to write a good will today than for your estate to pay attorneys to argue over your homemade will tomorrow. There are several things that your will can accomplish. The most obvious is that you can direct how your property will be distributed. Those persons that you name in your will to take your property are called beneficiaries. You get to select your own beneficiaries by naming them in your will. When you do name them, you should provide for several contingencies because you don't know who will be living at the time of your death. For example, if you're married and have children, you may want to leave everything to your spouse and provide that if your spouse dies before you or at the same time, then everything is to go to your children. Well, you should also provide for the possibility that one of your children could die before you. If that were to happen, where would you want that share to go? To his or her children, or to your other children? What if you were not survived by either a spouse or children? You may want to provide for that possibility as well. Now, I know it's not easy to think about your own death, and it's probably more difficult to think about your spouse or children dying before you. As uncomfortable as that might be, you'll have a much better will if you do plan for those possibilities. Another benefit of having a will is that you get to choose your own executor. The executor is the person who is appointed to administer your estate. The person you name to be the executor does not actually become your executor until your will is probated and the probate court officially appoints him. The executor has three main functions: to gather and protect your assets, to pay your debts and expenses, including any taxes, and to distribute your remaining assets to your beneficiaries. Your executor should be someone whose integrity and judgment you trust. It helps if your executor has some business sense, but that is not an absolute requirement if he or she has enough common sense to seek the assistance of professional advisors. Some people will name their attorney or a bank to be the executor. Now, most married people will name their spouse as their executor, but whether you're married or not, your will should provide for one or two alternates in case your first choice is unable or unwilling to serve as executor. You may name more than one person to act as executor jointly. They are called co-executors. This may be appropriate in some cases, but because both co-executors generally have to agree on everything and sign everything, it may be more inconvenient than it's worth. Another thing that you can do in your will is to name the person you want to be the guardian of your children in the event you are the last surviving parent. The guardian is the person who is appointed by the court to raise your children until their 18th birthday. Normally, the court will follow your wishes as expressed in your will. For those who do have minor children, this is often the most difficult decision to make. As with the executor, it's best if your will provides for one or two alternates. One other thing that you can do in your will is to set up a trust and name a trustee. Now, a trust is a special legal arrangement that divides ownership or title to property into two parts: legal title and beneficial title. The trustee is the person holding the legal title. He controls and manages your property according to your instructions for the benefit of the beneficiaries who hold beneficial title. Basically, a trust is a way that you can leave your property to someone such as your child, but have someone else, the trustee, manage that property for the child's benefit. Not only can you name the trustee, but you can specify how and when the trustee is to distribute the property to your child. Again, your will should allow for one or two alternates. A trust that you set up in your will is called a testamentary trust, and the trustee is called a testamentary trustee. Now here's an example of how a trust can be useful. Let's say your will leaves everything to your spouse and then to your children if your spouse has died before you. But if your children are minors, the court will normally have to appoint a guardian or conservator to manage their estates. Many states require the guardian to post a bond, file an inventory, file accountings with the court every year. Often, the guardian must get permission from the court to spend any of the money for the children. Not only that, but as soon as the minor becomes a legal adult, usually 18, the child gets it all outright. Most 18-year-olds aren't ready to handle that. On the other hand, if you set up a trust for your children, you can specify whether or not the trustee must post a bond or file inventories or accountings with the court. You can also give the trustee as much or as little discretion about how to spend or invest the assets. You can also specify the age that the trustee is to turn the property over to the child. Unless you have a strong opinion, I normally recommend age 25, or sometimes half at 25 and the other half at 30. In other words, your trustee can make sure that the funds are used wisely, such as to pay for their college education or to put a down payment on a house, before he has to turn it over to them outright. As I mentioned earlier, all of your property is not necessarily probate property. That is, some of your assets may not be controlled by your will. Some property that is titled jointly and property such as life insurance that has a death beneficiary are the two most common types of non-probate assets. First, let's talk about property titled jointly. Title to property means ownership. Sometimes we refer to a document as the title, such as an automobile title or a deed, but that document is just the written evidence of ownership. If the title to property is titled solely in your name, you are the sole owner. But if property is titled in more than one name, it is jointly owned property. There are different types of jointly owned property, and we'll be talking about the most common ones: tenancy in common, joint tenancy with the right of survivorship, and tenancy by the entireties. While the rules for joint property may vary slightly from state to state, the characteristics I'm about to describe are the most common. Tenancy in common is the type of joint ownership where you own an undivided interest or share in the whole asset. During your life, you can transfer your interest. You can also ask that the property be partitioned or divided. If you are a joint tenant, your undivided interest passes as part of your probate estate at your death. Therefore, your will does control this asset. Joint tenancy with right of survivorship is the same as tenancy in common, except for one big difference. At your death, your share passes to the surviving owners automatically. It is not a probate asset, so your will does not control. In other words, upon your death, you do not have any say over who gets your share. Tenancy by the entireties is a special type of joint ownership allowed only between husband and wife, and it usually applies only to real estate. While both you and your spouse are living, neither one of you can transfer your interest in this type of property without the other one joining in. Also, as long as you remain married, neither one has a right to partition the property. And upon the death of one of you, the property passes automatically to the surviving spouse. So this is not a probate asset and is not controlled by your will. Community property is another special type of jointly owned property between husband and wife. Community property only applies to property that is acquired during marriage in one of the 8 community property states. Upon your death, half of the community property automatically belongs to the surviving spouse, but the other half is probate property and passes under your will. Some people want to use jointly owned property as a way to avoid probate for convenience. That may be a good idea for your primary residence or your household checking account, but it may cause some problems when other assets are involved. As I have just discussed, you lose control over how some of your jointly owned property passes at your death. And some jointly owned property needs the signature of both owners. One of the joint owners could become incompetent or could refuse to cooperate. This can cause problems that you had not anticipated. As you can see, how you title your property is another estate planning decision that you have already made. And since the different types of jointly owned property are treated differently for probate purposes, it is important to know what type of jointly owned property you have. Let me take you through some typical examples of jointly owned property. If you have purchased real estate during your marriage, your property is most likely tenancy by the entireties or joint tenancy with right of survivorship. That means that upon your death, the real estate will pass directly to your spouse, regardless of what your will says. If you live in a community property state, real estate purchased during your marriage is most likely community property. In that case, only one half would pass under your will. The other half would go directly to your spouse. Now, if you own real estate jointly with someone other than your spouse, you are usually a tenant in common. For instance, you and your siblings might inherit property from your parents. If you still own that property at your death, your share would pass under your will. To be sure whether you are a joint owner of real estate, your attorney should examine the deed and perhaps other documents as well. Most states allow several different types of bank accounts that involve more than one person. By far, the most popular type of joint account is the joint account with right of survivorship. During your life, the other person, the joint tenant, can access the account for your benefit as well as his own. At your death, the entire account will belong to the surviving joint tenant. Your will does not control this kind of joint account. A mistake that many people make is to put one of their adult children on their bank accounts so that child can access the money in an emergency or write checks for them if they become incapacitated. That child becomes the sole legal owner of the entire account at your death. You may expect that child to divide the account equally among all of your children. However, I've seen too many cases where that child refuses to share those funds. And even if you do intend that account to go to that particular child, your other children may think you intended him to split that account with them. I've seen both instances just tear families apart. Fortunately, there are better ways to let someone else access your bank accounts. One way is to have a power of attorney, which I will talk about later. Another way is to set up what's called an agency account. This allows another person to sign checks for you, but does not give him any ownership rights in the account. While you are living, both of you can access the account, but your agent does not have the right to use the funds in the account for his own benefit. Further, at your death, the balance in the account passes to beneficiaries under your will. And if you really do intend to pass the funds in a particular account to one person, you can accomplish that in your will. Now, on the other hand, you may not want someone to access your account during your life, but you do want that account to go to someone special at your death. A Totten Trust account will let you name a beneficiary. That person will get the funds in the account at your death, regardless of what your will says. Make sure your attorney knows what type of accounts you have so he or she can give you the advice you need when you're discussing your will and your estate plan. Do not rely on how your names appear on the bank statements or on the word of the bank employee to determine which type of account you have. The only way to be certain what type of accounts you have is to get a copy of the signature card for each account. Another type of asset that many people own jointly are stocks and bonds and brokerage accounts. If your stock is owned jointly with right of survivorship, it passes automatically at death to the surviving joint tenant. It does not pass according to your will. If your stock is owned jointly with another as tenants in common, your share or interest in the stock does pass under your will. As with bank accounts, do not rely on how the names appear on the brokerage account statements to verify title to your securities. You must examine the actual stock certificates if you have them. If you have a brokerage account, you must examine the documents you signed when you set up the account. As I mentioned earlier, in addition to some types of jointly owned property, there are some assets that allow you to designate a death beneficiary. Most of you are familiar with life insurance or IRAs. There are a variety of other retirement plans and employee-related benefits that allow you to name a death beneficiary as well. These are all contracts that provide how benefits will pass at your death. These benefits do not become part of your probate estate unless your estate is the beneficiary. And because they are not part of your probate estate, these funds are not subject to your creditors. For example, if you die after a long illness, your medical bills and other debts could be, say, $200,000. Let's say your estate is $150,000 plus a $100,000 life insurance policy. Your entire probate estate would have to be used to pay your creditors, but that $100,000 life insurance would go directly to the named beneficiary on the policy. It would not have to be used to pay your debts unless your estate was the beneficiary of that policy. So, in many cases, it is appropriate to name an individual as a beneficiary. For instance, you may name your spouse as the primary beneficiary of your life insurance or IRA. But if you want the proceeds to go to your children in the event that your spouse dies before you, you may either name your children as beneficiary or alternate beneficiary. Or you may name your estate as the beneficiary. There are some serious problems with either one of these choices. If a minor is a beneficiary of these kinds of death benefits, a guardian or conservator will have to be appointed by the court before the proceeds will be paid out. Then the proceeds will be paid to the guardian and come under the supervision of the court. In most states, the guardian will have to file inventories and annual accountings with the court and get the court's permission to spend any money for your children. This can be costly and cumbersome. In order to avoid the guardianship problems, some people will name a close relative as the beneficiary. This is done so that the relative can use the money for the child's benefit. This is one of those proverbial situations where a little bit of knowledge can be dangerous. I strongly recommend against this approach. Even if your relative is completely trustworthy, there are things in his life that are outside his control. If that relative gets divorced or gets a judgment against him or dies, those funds that he's holding for your child are legally his. They could easily end up going to someone other than your child. Now, some people will either not have a beneficiary or name an alternate beneficiary, or they will name the estate as the beneficiary. If your named beneficiaries are not living when you die, the proceeds of these benefits will be paid to your estate and go through the probate process. They then become subject to your creditors. The solution to all of these traps is very simple. Have a will that includes a testamentary trust. Whenever you would have named your children or your estate as the beneficiary, you should name your testamentary trust as the beneficiary instead. Your will should also have a provision that states that any such benefits received by your trust cannot be used to pay your creditors other than estate taxes. Even if your children are not minors, you may want to do this so that these death benefits follow the same distribution pattern as your will. Now, your will is a document that does not take effect until your death. However, there are other estate planning documents that may be useful during your life that you should consider getting. A durable power of attorney is a document in which you give another person the power to act on your behalf for financial matters. It is durable because it is effective even if you become incapacitated or incompetent. The attorney in fact is the title of the person you name to act as your agent. Now, this person does not need to be a lawyer. Most married people will name their spouses as their attorney in fact, and very often an adult child or a close relative or friend as the alternate. The power of attorney is especially valuable if you do become incapacitated. Without a durable power of attorney, a court will have to appoint a guardian to manage your estate while you are incapacitated. This can be expensive and time-consuming, and your financial matters may become a matter of public record. I highly recommend a durable power of attorney if you can name someone whom you completely trust. Another important document you should consider is the living will. With today's medical technology, many people have a fear of being kept alive by extraordinarily artificial means. A living will allows you to retain some control over whether your life will be prolonged by certain life-sustaining procedures if you have reached a certain physical condition. You can state your desire for a natural death and give your doctor permission to withhold or withdraw certain life-sustaining procedures. And finally, the healthcare power of attorney is a related document in that you can name another person, sometimes called the healthcare agent, who can make healthcare or medical decisions on your behalf if you're not able to make your own decisions. Your healthcare agent is usually a family member. The decisions made under a healthcare power of attorney may be life and death decisions, or they may be the type that are routine medical decisions. For powers of attorneys, living wills, and healthcare powers of attorney, you may be tempted to use forms that you get out of a magazine or from some other source that may not be written for the particulars of your state. As with wills, the laws vary from state to state. Even the exact names of some of these documents may vary. Your attorney will be able to draft these documents so they are valid where you live. My spouse and I want the same things in our will. Can we make a joint will? Do we both need separate wills? Yes, you and your spouse can make a joint and mutual will, but I strongly recommend against it. In fact, I don't know any attorney who would recommend one. One of the great things about your will is that you can change it as often as you want. Your circumstances and desires may change over the years, and the tax laws may change as well. With a joint and mutual will, after one of you dies, the surviving spouse is contractually bound to keep that same will. You may outlive your spouse for 4 years or 40 years, so you should each have a separate will. Will my will be valid if I move to another state, or do I have to make another will? If you move to another state, your will must conform to the laws of that state. Each state has its laws on how to make a valid will. It is possible that your will may be valid in more than one state. But if you have a simple will, it's usually best to have a new will prepared by an attorney in your new state. If you have a complex will that still meets your needs, it may make more economical sense to have a codicil made in the new state. A codicil is an amendment to your will, and it will have the effect of making your will conform to the laws of the new state. If I don't make a will the state take my property? No, the state will not usually take your property. If you don't make a will, the state will control who does take your property. If you die without a will and no one can find your relatives, or you only have very distant relatives, then your property may go to the state. The laws that govern this are the laws of escheat, and they vary from state to state. If I die without a will, won't my spouse get everything anyway? Without a will, it is very likely that your spouse will not get everything. Although the laws of intestate succession vary from state to state, most, if not all, states provide that your spouse will have to share your probate estate with someone else. Usually your children will get a share. In some states, if you die without children surviving you, your parents may get a share of your estate. Do I have to leave my spouse anything at my death? No, you don't. However, most states have laws that protect the surviving spouse. These laws are designed to ensure that your spouse gets a certain share of your estate. If your spouse does not get a certain minimum amount, he or she may have the right to contest your will in order to get that share. Do I have to leave my children anything at my death? In most states, you do not have to leave your children anything. However, if you have a child born after you make your will, he may be entitled to a share of your estate unless your will provides otherwise for any of your afterborn children. Do I have to list my property in my will? No, you don't. You only need to mention certain property in your will if you want to make a specific bequest. A specific bequest is when you leave something specific to a beneficiary in your will, such as a piece of jewelry or cash. While you may have one or two specific bequests, most people leave the bulk of their estate to beneficiaries by percentages or fractions in their residuary bequest. The residuary bequest is the bequest of all the rest and remainder of your estate after your specific bequests have been made. When it comes time to distribute the property under your will, specific bequests are distributed before residuary bequests. So, if you leave a large specific bequest, there may be little or nothing left to distribute under your residuary bequest. Once I've made a will I ever need to change it? If your will was valid when you made it, it generally remains valid until you die or until you revoke it. However, You should review your will and your estate plan every 2 or 3 years to make sure that it still meets your needs and desires. Not only may your circumstances change, but the laws may change. So, the will and estate plan you make today may not work for you in 5 or 10 years. Should I give a copy of my will to my executor or to my children? I normally recommend that you do not give a copy of your will to your executor, your children, or anyone else who might have an interest in your estate. You never know what the future holds, and you may want to change your will. It's better not to have copies floating around that may be obsolete. This could create confusion, hurt feelings, and unfulfilled expectations. I do recommend that you tell your executor where your original will is located. Where should I keep my will? Keep your will in a safe, secure place. Although some may disagree, I recommend that you keep your will in a safe deposit box. Some states require your safe deposit box to be temporarily frozen when you die. Check with your bank to determine what the procedure is for accessing your box after you die. Even though it may cause a slight delay or inconvenience, the peace of mind is worth it. I've heard of too many stories about family members coming into the house just before or just after a death occurs. If the will does not suit them, they may take the will or destroy it. Keep a copy of your will at home with a note describing where the original will is located and the procedure for getting into your safe deposit box. Now you're ready to plan your will and put together your estate plan. One of the first things you should do is gather information about your loved ones and your assets. You can use the enclosed estate plan information sheet to assist you. When you list your assets, you don't have to be exact about the amounts, but you do need to know exactly how they are titled. Once you have gathered your information, begin making your plan. Who do you want to take your property? Do you want to make any specific bequests? Be sure to plan for contingencies in the event a loved one dies before you. Who should be your executor? If you have a minor child, who should you name as the guardian? Is there a minor child or anyone else that you need to protect with a trust? If so, who should be the trustee? You may want to name the same people for each of these positions, and be sure to have 1 or 2 alternates for each of these roles. And don't forget that some of your assets may be non-probate assets that will not be controlled by your will. You may need to make changes in the title to some of your joint property or in the beneficiaries of your life insurance or retirement plans to coordinate with your will. I hope this program has given you some valuable insight and helped you in your decision to make a will and an estate plan. And while I've tried to cover most of the topics associated with wills and estate planning, please remember that no single reference source can possibly cover every circumstance or detail on this subject. After you have gathered your information and put together a framework for your estate plan, you should consult with your personal attorney. An attorney experienced in this area can not only draft a will to meet your needs, but can discuss your plan in detail and offer you alternatives and solutions. If you don't have an attorney, check your local yellow pages under attorneys or ask your friends or neighbors for a recommendation. Then make an appointment to talk it over with a professional. And remember, the more prepared you are when you do draft your will and estate plan, the more you'll enjoy the peace of mind that you and your loved ones deserve.